over. I don't know if you'll think of all of us as stars after what we have to tell you today. It's more to sort of be aware of in terms of employment arrangements and managing your workforce. But hopefully this will assist in everybody sort of getting across some of the key changes. Make sure my control of the slides is working here. There we go. So as you'd probably all be aware, there's been a whole raft of changes that have been progressively introduced over the last couple of years, broadly collectively known as the closing loopholes changes. So we've selected 3 key changes, most of which are quite topical because they're going to be introduced at the end of August, so next month, most of them on the 26th. Some of them are already in play and we'll flag what those ones are. But basically, these are some of the 3 key topical changes in the space that are coming up. So we've got changes to the definition of employment, and specifically that's relevant in terms of contrasting that with an independent contracting arrangement. We've got changes to casual employment. They've been tinkering with casual employment for a little while with legislation. So all of you would probably be aware of the issues that have arisen around conversion and all that sort of stuff. We've got some more changes to the conversion pathway, and Laura's going to talk about that in a little bit of detail. And then we'll close out just by having a quick look at the right to disconnect. Try to keep the pace nice and brisk so I don't get into Laura's time. So slides are misbehaving a little bit, but okay. So we'll start off by looking at the definition of employment. This has got a bit of history, this area, and traditionally this is always something that's been dealt with in the case law. So there's a body of cases going back decades where courts have had to address this issue of whether a particular worker that's engaged by a business, whether they're an employee or whether they're an independent contractor. So usually this is in the context of a dispute where the worker will assert that they are actually an employee and the business will say that no, they're an independent contractor. That's relevant, of course, because when somebody's an employee, they have access to leave and national employment standards, all those different rights and obligations that apply under the Fair Work Act come into play. So it's obviously very important for businesses to understand what the nature of the relationship they're engaged in is, because it has all sorts of consequences. So if we go back before 2022, there was this very clearly established multi-factor test where basically the court would look at a whole range of different attributes and characteristics of the relationship to make an assessment about whether this is an employment relationship or whether this is an independent contracting relationship. And although the contract and what the contract says has always been a relevant factor, the courts would look more beyond the contract if they had to how things were working in practice. So this does give you a more detailed and nuanced view of the relationship, but the problem that it creates is obviously one of certainty, where you can have a situation where there's a very clear contract that says this is not an employment relationship, this is an independent contracting relationship, and then you can have that sort of subsequently turn out not to be the case. So the case law is developed over a long period of time. It's always been a very tricky area. We advise clients a lot in this area, and it's always an area where we're often difficult to give a definitive view. You're sort of talking in terms of likelihoods and a level of risk. So in 2022, the High Court made some changes to those principles with some high-profile decisions they handed down. And basically what they said was that you're still looking at the same factors in terms of, you know, for example, some of them are listed up there, the degree of control that a business has over the worker, whether they're deducting tax from their wages, whether the worker is able to delegate or subcontract, all those factors are still relevant. But the courts basically said we need to kind of rein this in and start looking more at the actual agreement between the parties. So we need to look at the rights and obligations that are created under the contract to get that idea of what when we're assessing the factors. So a really good example of this is delegation. So often you'll have an agreement that says that the worker is entitled to subcontract or delegate the work. Usually that's subject to getting permission from the business. So you can't just delegate to anyone, but if you get reasonable sort of permission from the business, you can sub somebody else in to perform the services. Now, obviously that's never going to happen in an employment relationship. The essence of employment is that you're there to kind of personally perform those services yourself. So that can be a really pivotal factor. And so in the 2022 sort of decision, and this is the law that still applies until the end of next August, the court would say, well, is there a right to delegate or subcontract under the agreement? And as long as the contract isn't a sham, as long as it's there and it's an enforceable right, they'll say, well, that's what's important. It's about the rights and obligations because that's what defines the nature of the relationship. Whereas under the previous approach, a court might be more inclined to say, well, did the parties ever really seriously contemplate that there was going to be any delegation or subcontracting? Did anybody actually ever exercise that right? How did it sort of play out in practice? So they're a lot more interested in not just looking at what the rights and obligations are, but they're looking more at the practical reality of the relationship. And as I said, that does give you a more nuanced and in some ways a more accurate view, but it's really bad for certainty. You don't have that guarantee and that certainty that you're able to rely on the terms of a contract freely entered into. And in a lot of these cases, you'd have a situation where sometimes for years and years and years, both the worker and the business would genuinely believe that it was an independent contracting relationship. So it wasn't a sham, it wasn't anything, there was no trickery involved, but then a court can come along and say, well, actually, when you analyze this from a legal perspective and you look at the characteristics of the relationship, it doesn't matter that you've got an agreement that explicitly says that this is an independent contracting relationship. It's not. So basically what's happened or what's going to happen with this latest round of changes is we're basically just moving back to the pre-2022 position. But this is the first time that that's ever been specifically provided for under legislation. So this has always just been dealt with in case law before. Now there's going to be a part of the Fair Work Act that says you have to look at the quote, real substance, practical reality, and true nature of the relationship. So your contractual terms are still going to be a relevant factor, but they're going to be one among many factors. And we'll have a look at what some of those factors are on the next slide. But basically, it is focusing on that whole constellation of factors, multi-factor test. So you're weighing all those up together. So don't seem to be able to move the slides. Thank you. So these are some of the factors that are typically coming into play here. So as we mentioned before, degree of control. So how much control there is over when, how, and in what manner the worker is performing the services. Do they have to perform it in a specific place? Do they have to, obviously with an employee, typically there's sort of hours of work. With an independent contractor, it might be more, to skip down to the bottom factor, it might be more about paying them to complete a particular result or to sort of achieve an outcome, as opposed to paying them for their time. The second factor there about providing tools, uniform, and equipment. Obviously, with employees, they'll often be given a lot more of that stuff typically, whereas with an independent contractor, if they're sort of running their own business effectively, they've got their own capital goods, they've kind of got their own kit and their own gear that they're kind of taking from job to job. And then we've already discussed that third one down there about whether the worker can subcontract or delegate the work. So to put it really simply, the kind of upshot of all this is that parties are now going to have less definitive control over the nature of the relationship that they're creating, because you can enter into an agreement that has all the the right terms to provide for an independent contracting relationship, but if for whatever reason the nature of the relationship as it plays out becomes a little bit different, that's going to be it's less easy to rely upon that sort of stuff. Now that's not to say that contracts aren't still going to be important. In fact, in some ways, they're more important because there is this extra risk and uncertainty that needs to be mitigated. So not only is the contract important for setting up the relationship and doing what you can to try to steer it in the right direction in terms of the kind of relationship you're creating, but it's also very important in terms of managing the risk associated with, well, what if it goes wrong? Not only if there are disputes just under the relationship generally, but if there is some sort of mischaracterization, there are things that you can put into place to kind of try to manage that risk. One of the things that's been introduced under the new legislation to sort of try to temper this a little bit and to give parties a little bit more certainty is this idea of these opt-out notices. They're not necessarily that great from an employer's perspective or from a business's perspective, because these opt-out notices, what they do is basically a worker can give a notice that says, I don't want to be covered by this new definition of employment. So they'd basically just be covered by the same case law principles that applied before. So it's not a guarantee that they won't be an employee, but it just means that they won't be covered by this new definition of employment. So if they give one of these notices, this new legislation doesn't apply to them. To give a notice, they have to be over the high income threshold. Now, it's not the same high income. Well, we don't know what the high income threshold is yet. It may be the same as the unfair dismissal high income threshold, which some of you might be familiar with, which is about $175,000 a year. But it's not necessarily going to be the same, and it might be a completely different figure. We're expecting it'll probably be somewhere around the same threshold, 175,000, which is it's indexed every year, obviously, to go up with inflation. So the idea is, your lower paid workers are going to have the protection of this new definition so that they're not inadvertently missing out on employment entitlements. But if you're earning over a certain level, then the rationale is, okay, well, you can have the choice whether or not you want to opt in or out of, whether you want to opt out of this definition. As I said, these notices can only be given by workers. So it's not necessarily, it doesn't give a lot of certainty to businesses, and even more problematic than that, a notice can be revoked instantly at any time by a worker. And if that occurs, then the notice ceases to operate and the definition is back in play. So, you don't really have something locked in. You don't have something you can rely on, but you might find that in certain situations, it's actually a lot more beneficial, for tax reasons or for whatever other reasons, for a particular worker to be doing things as an independent contractor. But nevertheless, it's kind of an imperfect way of tempering to some degree this issue that arises from the changes more broadly, which is that you can less easily rely on predictability of the nature of the relationship you're creating. So we'll just touch quickly as well on sham contracting, which is sort of a related area here. These changes have actually already come into play, but they kind of link in with the other changes we've been discussing that are still upcoming. So sham contracting, for those who don't know, is basically where you engage somebody as an independent you represent to them that you're engaging them as an employee. No, you represent that a relationship of employment is one of independent contracting. So you engage somebody under what you're saying is an independent contracting relationship, but they're actually an employee. So that's the idea, is you're effectively, the classic example is there was a widespread practice in the cleaning services industry of engaging cleaners who basically were just casual employees. They weren't really running a business of their own or anything like that. They were working very set hours. They were under the direction of the business, but you're doing that as a way usually to avoid employment entitlements, annual leave, all those sorts of things. So that's sham contracting. There's always been a defense to sham contracting, which is historically been to say that you didn't know that it was actually an employment relationship and that you weren't reckless. So that was the defense. And one of the things that's changing is they're basically making it harder to rely upon that defense. So now you have to prove that you reasonably believed that it wasn't an employment relationship. It's just another layer of difficulty associated with all this uncertainty that exists around independent contracting and being able to identify the type of relationship that's being entered into. And so in conjunction with making it going back to a situation where it's a little bit more difficult to identify what the relationship is and making it more difficult to rely upon the defences if there is any issue around sham contracting, there's also an increase to penalties as well. So there's maximum civil remedies that can be ordered in cases of sham contracting have gone up by about 5 times. So now into the hundreds of thousands. That's only a maximum penalty, but obviously it's, when taken together with all the other changes, it does basically suggest that it's more important than ever to get advice if you are looking at engaging an independent contractor, because it is a really tricky area. It's something that takes a lot of care and attention, both in terms of making sure that this is the right fit for the worker you want to engage, that this is the way to go, independent contracting versus casual employment or whatever else, but also to set up the relationship so that you've got the best possible chance of managing the risks and steering the relationship in the right direction. So that's the sort of definition of employment section. And now Laura's going to talk a little bit about what's going on around changes to casual employment. So I'll just hand over to her.
Thanks, Barney. The next closing loopholes change I'll talk about is the change to the definition of casual employment and the casual conversion pathway. So coming into effect on the 26th of August 2024, the Closing Loopholes Act will amend the definition of casual employment and will introduce new requirements relating to the casual conversion pathway. So currently in the Fair Work Act, a person is considered a casual employee if they accept an offer for work from an employer, knowing that there's no firm advance commitment to continuing an indefinite work according to an agreed pattern of work. Under the new definition of casual employee, a person is a casual employee if the relationship is characterized by an absence of a firm commitment to continuing an indefinite work, and the employee would be entitled to casual loading. The Fair Work Act sets out a number of factors to consider when determining whether the employment relationship is characterized by an absence of a firm advance commitment to continuing an indefinite work. So these can include the consideration of the real substance, practical reality, and true nature of the employment relationship, consideration that a firm advance commitment may be determined by the contract itself or mutual understanding between the parties. So basically how the contract is written and performed can infer that advance commitment. Consideration of the following factors, which also indicate a firm advancement, include whether the employer can elect to offer or not offer work, and whether the employee can accept or reject that work, whether it's reasonably likely that the continuing work will be available in the future, whether there are employees performing the same kind of work, and if the employees engage in a regular pattern of work, which can include sort of fluctuations and variations over time.
So Laura, just to highlight something there, we've got that same wording about real substance, practical reality, and true nature of the employment relationship, which we also see in the more general definition of employment that's been introduced. So to kind of put it really succinctly, we're moving again away from sort of looking at the terms of the offer. So making somebody offer and saying very clearly in a casual employment agreement, there's no advance commitment to continuing work. And now it's much more that holistic look at, oh, how does the relationship operate in practice? What's the true substance and all that sort of stuff.
Yeah, exactly. It's the same sort of flavor as those independent contractor changes. It's definitely worth noting that a sort of regular pattern of work will not of itself indicate that firm commitment to indefinite work. An employee who has a regular pattern of work might still be a casual employee if there's no firm advance commitment to continuing indefinite work. So, as you said, Barney, basically now the classification of casual employment requires that holistic assessment of all the circumstances. The impact of this new definition means that employers need to consider now both the terms of the contract as well as the way the employees actually work to meet that new definition. To best prepare for the change, employers should undertake a review of the terms of their casual contracts to ensure that they meet that new definition. It would also probably be a prudent time to audit the current casual employees in the workforce in order to assess the risk of them being found to be permanent employees. In addition to changing the definition of casual employees, the Closing Loopholes Act also amends the casual conversion pathway to full and part-time employment. So currently under the legislation, employees are required to offer casual conversion to full or part-time employment if the employee has been employed for a period of 12 months and the employee has worked a regular pattern of hours for at least 6 months, which could be converted to full or part-time hours without significant adjustment. The offer of casual conversion is required to be given to the employee within 3 weeks of their 12-month anniversary. However, from the 26th of August, casual employees will have the right to be offered full or part-time positions after just 6 months of employment or 12 months if they're a small business. In addition, the Act has established the employee choice framework, where casual employees may now initiate this change themselves by providing their employer with a conversion notification if they believe that they don't meet that definition of casual employee any longer. A casual employee will be able to issue this written notification in circumstances where they believe that their employment no longer meets that definition. They're not currently engaged in an ongoing dispute about conversion with their employer. They've been employed for more than 6 months or 12 months in the case of a small business. And in those 6 months or the 6 months before, they haven't received a response from their employer of rejecting a notification or had a dispute about casual conversion. The Closing Loopholes Act also sets out how employers are required to respond to these written notifications. It includes the requirement to respond within 21 days and the requirement to consult with the employee about the notification prior to providing a response. If an employer intends to accept the notification, the employer must discuss the factors such as part-time or full-time hours and days of work with the employee, If the employer does not accept a notification, then they have to provide their reasons for the refusal. Some grounds for refusal include that the employee still meets the new definition of casual employee, that there are sort of fair and reasonable operational grounds. So that includes substantial changes being required to the way in which work is organised. There would be significant impacts on the operation of the employer, or substantial changes to employment conditions would be reasonably necessary to ensure that the employer doesn't break any rules that would apply to the employee. It's important to note that an employer can't reduce or vary an employee's hours or patterns of work, or terminate the employee sort of as a way of avoiding this obligation. The existing provision for requesting casual conversion will continue to apply to employment relationships entered into before the commencement of the Act on 26th of August for a period of 6 months from commencement. Basically, the new employee choice framework differs from the previous pathway, as an employee may only request conversion to full or part-time employment by claiming that their job has already become an ongoing one. Once the changes are effective, merely sort of having received casual work on a regular basis for 6 months won't be enough, as it would have previously been under the previous pathway. The removal of the obligation on employers to offer casual conversion lessens the administrative burden on employers. The closing loopholes changes will shift the onus onto the individual employees themselves to drive any potential changes to their employment. Employers, however, will need to have defensible reasons for not agreeing to a notification and must be aware of the procedural requirements for responding to the notifications. With this change, employers must also issue casual employees with the Fair Work Casual Employment Information Statement, not only upon commencement, but now also after the employee has been employed for a period of 6 months and then again at 12 months. It basically serves as a reminder to the casual employee of their right to casual conversion at the sort of relevant points in time. Finally, if a dispute arises between the employer and the employee regarding the casual conversion pathway, the parties must first try to resolve the dispute at the workplace level, so by discussion. If it can't be resolved there, a party might refer to the dispute to the Fair Work Commission. In the first instance, the Commission will generally be required to resolve the dispute in an informal way, so mediation or conciliation. If the dispute can't be resolved informally, the Commission has the power to arbitrate. Any outcome reached at arbitration might be legally binding on the parties. I'll now hand back over to Barney to talk about the right to disconnect.
Thanks, Laura. And yeah, just I suppose finishing up on that point about casuals, what you mentioned about auditing current casual arrangements, it's always a good idea to have a look around and see if you've got any of those kind of full-time casuals on the books. Often businesses will have those casual employees who, they've been working full-time or pretty close to full-time hours for a long period of time. Often, the employees like that arrangement as far as it goes because they're getting the loading, they're getting more pay up front. But it is important just to be aware of, where you might be getting those requests for conversion. And in some cases, just having the certainty of locking somebody in on a permanent arrangement, if it's operationally feasible, is something you can consider as a way to just kind of ensuring you're not dealing with any unexpected surprises. But it's always a good idea to just keep an eye on those levels, the patterns of work people are working, just making sure there's where your kind of potential issues are around all that sort of stuff. And as Laura said, also making sure your employment agreements are up to date and that they're dealing with all the latest legislative changes. So the right to disconnect, this has received quite a lot of public attention from what we've seen. There's been a lot of kind of media attention and a lot of consternation about what this means, particularly in a post-COVID world where, we've moved to more flexible ways of working from home, increasingly using platforms like Zoom, like we're using right now, Teams, got employees with access to their emails all the time, particularly white collar workers. Obviously, that presents a lot of opportunities for increased productivity and it has a lot of benefits. But the rationale behind this change that's been implemented, that will be implemented, I should say, the right to disconnect, is about just kind of making sure that things don't get out of hand. So the rationale can sort of be succinctly summarized as, when you clock off, you should have the right to log off. So if you're not on the clock, if you're not getting paid, there shouldn't be any sort of obligation to be constantly at the beck and call of your employer. So 26 August 2024 is when the changes are going to come in for most businesses, or 1 year later for small business employers. So that's less than 15 employees. And the way this legislation is shaped, it is around this right to refuse. But it's not a situation where there is this unequivocal, unabridged, completely untrammeled right to refuse to deal with any work-related matters outside of ordinary working hours. The legislation is very deliberately framed in terms of a presumption that there is this right to refuse to read, monitor, or respond to contact from employers or a third party outside of usual working hours. But that's only if the refusal is not unreasonable. There's a few double negatives there, but basically it's framed in terms of presumption that if you're off the clock, your time is your own. But you can't refuse if the refusal is unreasonable. And in practice, there are going to be a lot of situations where employees can reasonably be expected to attend to matters outside of working hours. So there's a whole range of factors that will be considered in terms of whether a refusal is unreasonable. So firstly, obviously the reason for the contact. Is it a once-off thing? Is it an emergency? Is it something that actually needs to be dealt with right now? How is the contact made? Sending an email out of hours and just leaving it for somebody to deal with, the next day is obviously very different from calling somebody up and demanding their attention instantly on the spot. A lot of this stuff is very common sense kind of stuff that if you're dealing with flexible working and, you've got employees working remotely and people with access to all these sorts of new platforms that do bleed those borders, these are the kind of things that you have to negotiate with people just from a people management perspective in terms of making sure that expectations are reasonably set and that, everything's being handled smoothly. Obviously being compensated specifically for working out of hours. So if you're getting an on-call allowance, or if you're a very highly remunerated, to go to the next point, a senior employee who's getting paid a lot and has a lot of responsibility, all of these factors come into play, as well as things like personal circumstances around carer responsibilities, family responsibilities. So, there might be certain times for particular employees where particular contact is not really going to work for them. That's something that goes into the mix as well in terms of whether a refusal by an employee is unreasonable. I suppose the big game changer, practically speaking, is this new jurisdiction that's been created with the FWC for dealing with disputes. So now there's a situation where if an employee is asked to read, monitor, or respond to some kind of communications outside of working hours and they refuse, that could lead to a dispute, obviously. The legislation mandates that people will try to deal with these things at a workplace level initially, so that you have to have a discussion and try to resolve it at the workplace level. If that fails, either employers or employees can make applications to the Fair Work Commission. And what the new laws envisage that might look like is that if an employee refuses to deal with something outside of work hours, they might make an application to the Fair Work Commission if they apprehend that they're likely to be subject to some kind of disciplinary action or terminated or some kind of adverse consequence. So they might apply to the FWC and say, hey, I've made this refusal. My employer's jumping up and down about it. I want you to sort of basically declare that this is reasonable and to protect me from any adverse consequences. Or on the other side, if the employer has asked an employee to deal with something and they're refusing, the employer can get an order basically saying, no, this is reasonable. This refusal is unreasonable. And so that they can either clear the way to take disciplinary action if they need to, or they can, if the employee follows the order and does what they're supposed to, then obviously that will resolve the issue as well. So it remains to be seen whether this disputes jurisdiction will get much of a workout. You never really know when these new sort of jurisdictions are created, how popular they'll be. Sometimes they come up and there's a flurry of activity and people really flock to them. Sometimes they kind of end up being a bit of something that sits on the books and doesn't get used a lot. We also don't know, of course, how many things will just kind of be dealt with at the workplace level, because in a lot of ways, this stuff isn't super new. Now it's a few years old, where parties have been having to deal with all these sorts of issues and negotiate them at the workplace level anyway. But no doubt there will be some people who are very keen to rush off to the commission, as there always are. But yeah, we'll have to see where all that leads. So that's the right to disconnect stuff, and those are the sort of three areas that we wanted to cover. We're happy to take any questions if there are.